So I am very pleased to introduce our speaker today, Varu Chilakamarri. She joins us from the Department of Justice, but before that, she attended Ohio State University and graduated from Georgetown Law, after which she then clerked for the Sixth Circuit and the U.S. Court of Appeals for the Federal Circuit. She joined the Department of Justice in 2006 via the Attorney General's Honors Program and worked for both the Civil Division and the Office of the Associate Attorney General, and received awards for outstanding service in 2013 and awards from the Civil Division, after which she joined the Environment and Natural Resources Division at DOJ and has served there in the appellate section for several years now. Since joining ENRD, she has worked to establish the Animal Welfare Enforcement Program and now serves as counsel for the Animal Welfare Enforcement Program. And we're very excited to welcome Varu, so please join me in welcoming her.
So thank you very much. I would say hold your applause till the end and see if it's worth it. But you have free food, so it's at least worth that, right? I'm Varu Chilakamarri, and I am the counselor for animal welfare litigation in the Environment and Natural Resources Division. I'm also just an appellate attorney in the Environment Division, so sort of wear two hats. My title, the counselor for animal welfare litigation, is a new position that just sort of started 2 years ago, and I helped to kind of establish that in the division. So we're still working things out and trying to figure out the best way to use part of my time. But Chris invited me to talk today about the DOJ's animal welfare program and the genesis of how we kind of got animal welfare to have a priority in the department and have a priority at Main Justice. So I think what I'll do is tell you a little bit about how we put animal welfare kind of in the limelight at the department, tell you a little bit about how since about 2015 when we got our program formally started, what we've been doing, give you a snapshot of some of the cases that we have been working on, and then kind of close with some thoughts about where DOJ and where our work fits in the general animal law space, because I know this week you guys have the really wonderful opportunity of having a lot of diverse speakers from public, private sectors, and I think we all kind of play a unique role in this area. And so we'd love to hear some of your comments and questions about that at the end. So to start with, I think it's best to kind of look back at kind of pre-2015. At this point, animal welfare, there was no place at Main Justice where anyone focused on animal welfare or talked about animal welfare enforcement. Basically, if you had a case, if there were going to be any cases brought under any of the federal animal welfare statutes, some things like dogfighting, cockfighting, cases against the animal under the Animal Welfare Act, cases under the Humane Slaughter Act, those would all have to have been brought through one of the 94 U.S. attorneys' offices. And so an agency would have to go to one of those regional offices where the activity occurred and try to convince that office to take on the case. So it was basically treated like any other sort of general crime, a general statute, and it was competing for the resources in those U.S. attorneys' offices, where they also handled all of the immigration cases, all the drug cases, the gun cases, the white-collar crime cases. And you also didn't necessarily get any kind of institutional expertise that was building up, because these cases are pretty rare. So kind of moving forward then to 2015, things began to change, and I think in large part because senior leadership at the department began taking notice and taking interest in animal welfare, and were starting to think about what they could do to actually make structural changes to improve enforcement. And I'll just take a little bit of a departure here to tell you about my own career path. I think many of you all are in law school right now, and so it might be kind of interesting to hear, because I think how things get changed in the department, kind of moving the department is like moving a big ship. And it's a vast federal bureaucracy, something that even when I started at DOJ, I didn't know there was 100,000 employees in the Department of Justice. When you consider kind of what we have the FBI, we have DEA, all of these components are all part of the Department of Justice. So making any kind of change, and I try to tell myself every day that making any kind of change in that kind of organization is a long process. So as you heard, I started at DOJ through the honors program, but before that, I was in law school, and I started in 2001 in law school, and I remember having a conversation with my torts law professor. It was a really, really creative thinker, great guy, and during office hours, he asked me in my 1L year, what are you interested in? What kind of areas of law interest you? And I was really interested in a lot of things, but I kind of bashfully said, environmental, maybe animal law. And he goes, animal law? That's not a thing. And just like, you really need to get some other plans if you want to have a career. So I was just really deflated after hearing that, because I thought, okay, I'm in Washington, D.C., where change happens, and this is where things get done for the country. I'm at a university with a professor who is extremely liberal, and this is academia. And if he's telling me I'm not being practical, I don't know what hope I have. So it was fine. I was like, well, there's lots of things I want to do. Graduated and clerked, and after clerking, I thought, I really enjoyed kind of the diversity of legal questions that I got to work on when I was clerking. I liked kind of not having the same question every day, the writing, the arguing, all of that. So DOJ was a natural fit for me, because that's where you kind of get that kind of nuts and bolts training, but you kind of get to do it yourself right away. So I started through the honors program, and I went to the civil division in the federal programs branch, which is where you kind of get the hands-on training, but you also get to work on some of the kind of premier constitutional litigation, APA challenges, kind of a lot of the things that you hear about on the front page of the paper. So it was a great experience, no animal law, but still great experience. And then I went on to work on a pretty controversial but also like high-profile case involving suing the state of Arizona, because in 2010 they passed a comprehensive immigration law of their own, and the federal government decided that that kind of law was preempted. So I got to work on that case, probably one of the most interesting and exciting cases. Again, no animal law, but that kind of elevated me and put me in touch with sort of the head of our division, who was Tony West at the time. And then when he became the Associate Attorney General, that gave me an opportunity. He invited me to come on detail to the Office of the Associate Attorney General. So this is the kind of very basic structure of DOJ. And does this have a pointer on it? Does this, if you click? Oh, I see. Okay, so I was here in this little box that has hundreds of attorneys, and suddenly I got to be in this office and see a whole swath of different agencies. And what that did was, we were not only kind of managing the litigating components. You have the civil division, you have the environment division, the antitrust, tax. All of these are litigating components where you are specializing in a particular area, working with the U.S. attorney's offices. But I also got to see this whole arm over here, grant-making components, and we also saw some of this, which is all the criminal, the law enforcement, the bureaus. Getting to see that was eye-opening, and it really gave a different vantage point, because DOJ doesn't just do litigation, but we also do a lot of legal policy work. And one of the roles of kind of people at the top, the senior leadership, is to not just kind of manage the department, but also look for ways to improve the department, look for ways to improve law enforcement, figure out kind of a legacy to leave behind, and kind of changes that you can make to actually improve the department's work. And in that capacity, our Associate Attorney General was kind of open to thinking about animal welfare issues. And so I just thought, well, this is a great opportunity, because we actually want to see what we can do. But really, nobody in our office knew whether DOJ did anything relating to animal welfare, because again, no one really talked about it back then. So I just Googled animal welfare DOJ, and I found one hit, and it was the Office of Justice Programs, which is this office over here, which I'd never heard of before. They work with states and local governments. They give grants to different entities, and they care about criminal justice issues. And so they had started a little internal working group with, they don't have lawyers, they have grant writers and policy analysts, and they had a little working group where they were studying the literature between the connection between animal cruelty and interpersonal violence. And they were looking at that. It's often called the link. They were looking at that literature because for them, that was an important component of criminal justice, who they give grants to at the local level. And so that was a great place to start. But that wasn't the only place. There were people across the department that were interested in animal welfare that we began tapping into. And it was, I would say this change actually came from the bottom up. It was really career attorneys in the civil division who had, for example, defended the constitutionality of the animal fighting statute. There were attorneys in the Environment and Natural Resources Division who saw a connection between animal welfare and environmental crimes and wildlife crimes. Things like even CAFOs and pollution, they saw a connection between those two. We had people in the FBI who were interested in animal welfare because they came across animal cruelty in their own investigations. They would come across animal fighting when they were investigating drugs and other crimes. They would come across animal crush violations when they're investigating child pornography. And so they saw all of these connections at the law enforcement stage. We also had the U.S. Attorney's offices. Like I said, animal welfare was, and it still is, litigated and prosecuted by the U.S. Attorney's offices. And we did have and were able to tap into AUSAs across the country who were interested in these issues. So we had the first, the U.S. Attorney's office in the Eastern District of Virginia. They prosecuted the Michael Vick case. They're part of the department, so we had them involved. The U.S. Attorney's office in the Eastern District of Tennessee, they were the first office to prosecute violations of the Horse Protection Act. So we gathered all of these folks. We had various working group meetings and tried to learn about what the department had done so far and what were the avenues for the department to improve the work in this area. So the first thing we did was we created a toolkit. There was an internal toolkit for prosecutors, but we were able to kind of build on the work that the AUSAs had done, but then put it together so that future U.S. attorneys' offices didn't have to kind of make up, every time they got a new case, and an AUSA in Minnesota gets a dogfighting case for the first time, they have kind of no resources. And this way, we put together a toolkit so that we could come from Main Justice and say, here are the sample briefs, here are the pleadings, this is how the U.S. Attorney's Office, pled the case this way. And so we created the toolkit. And then we had a listening session. This was the first time that the department ever had a listening session on animal welfare, and it was convened by the number 3 in the department. We invited folks from the state and local law enforcement to come and talk about how they deal with animal cruelty issues and the intersection between animal cruelty and public safety, because again, that was the nexus that the department shares. And one of the things that we learned, and I think it was somebody from the American Association of Prosecuting Attorneys, they kind of just said, it'd be really great if there was a place at Main Justice that handled or kind of looked at these issues so that it wasn't kind of just randomly dealt with across the board through the U.S. Attorney's Office. And it made a lot of sense. So this all took a couple of years, and so the next step was to actually propose a structural change. So what we did was we proposed a change to the U.S. Attorney Manual. It's now called the Justice Manual. It's basically the guide for how the DOJ operates. It tells you kind of what each component does and what their authority is. And we said, we can't not have the U.S. Attorney's offices prosecute these cases, but we also want a home for animal welfare enforcement at Main Justice. And the reason for this is, again, the decentralization, the lack of resources at the local U.S. Attorney's offices. Also, if you don't have a home at Main Justice, you will never build kind of the long-term institutional knowledge, and you'll never have anybody kind of at the national level looking at trends, looking at kind of how do we best interact with the client agencies and how can we better support them. You don't have those kinds of broad ways of thinking about it. And so we proposed to put animal welfare enforcement in the Environment and Natural Resources Division. And there was a little bit of a debate about where it's the best place, but in terms of overall what the divisions did, this seemed like the best place because we also have the Endangered Species Act, wildlife protection, and the ability to do prosecutions on our own. And so we convinced the senior leadership, the Attorney General. We also had to have the Attorney General's Advisory Committee, which is a committee of U.S. attorneys, sit down and vote on this. And it happened, pretty quickly, and I was surprised and was told later it was probably the fastest time that the AGAC has ever voted on something like this. And also because, in a way, they're kind of giving Maine Justice more authority, which they don't like to do. And so, but they did it. And I think that's a testament to kind of the support that we had for making this change throughout the U.S. Attorney community. Because they also thought, it's not that great to have to be alone out there in the regional offices without any support and without any institutional knowledge. So the Environment and Natural Resources Division now has authority for this list of statutes. These are the 6 federal animal welfare statutes. There are a lot of federal laws that deal with animals, but when we were thinking about kind of what fits in this bucket, our criteria were the federal statutes where animal welfare was the primary motivation for passing the law. It's not, and we already have the environmental statutes with the ENRD, but these were the ones where the primary impetus was animal welfare. There are a lot of other things going on in these 6 statutes. They were passed at different times, different historic conditions, but animal welfare is kind of the unifying feature. I like to think of these in kind of 2 categories. The first 2, animal fighting and the animal crush video statute. Many of you are probably familiar with these, but for those of you who aren't, these 2 kind of just outright prohibit a class of criminal conduct. There is no sort of space for doing these kinds of things. There's no space for dogfighting or cockfighting or for creating animal crush videos. There's no space for that to happen legally. And so they're strong, they're strict felonies. Animal fighting is a 5-year felony. Animal crush is a 7-year felony. And so there's no real administrative process. There's no permitting. It's straight criminal. And I think that's why you see a lot more work that we can do in that space, because if it's illegal and we investigate it and our law enforcement are seeing these kinds of crimes, it's kind of, there's not that many other tools. There's no escalation. It's just a criminal. The second class is a little harder. It's more challenging. These are the Animal Welfare Act, the Horse Protection Act, the HMSA, and the 28-hour law. These all regulate the welfare of animals in commercial settings, legitimate commercial settings, where you have primarily the USDA is the client agency that is administering these systems, giving permits. And what you see in these statutes is that Congress kind of envisioned a slow escalation of penalties and gave a lot of tools to the agency, the USDA, to permit and administer animal welfare violations. And there are criminal and civil judicial penalties, which is where DOJ can come in, but it's not the first kind of preference under the law. But these are the 6 statutes that ENRD now has. So great, we made this big change, and now what do we do? Turns out if you build it, nothing necessarily happens. You have to kind of implement it. So this happened in 2015. And we've been working on a couple of things. And I will say, sort of just kind of coming back to my own career path. So this was the time when I decided I wanted to go to ENRD. And so I was fortunate enough to be able to kind of keep my career status. And I went over to the appellate section so that I would have continue to be able to work on litigation, but also was able to help to implement the program that I got to work on creating in the first place. And so what I did was I became the chief of staff to the head of the division. And for 2 years, one of my main special projects, in addition to being the chief of staff, was to try to help the division kind of embrace this new program and integrate it into the work. And it's not necessarily an easy thing for the division because ENRD is over 100 years old, and the focus, and many of you probably see this, with kind of the old style environmental systems, initially it was called the Lands Agency. They dealt a lot with takings and land acquisition, and then it slowly expanded to include environmental pollution and eventually wildlife crimes. So plopping animal welfare onto this old institution was a challenge. It's also, probably it was the biggest expansion of their authority in over 30 years. And I was telling Kristen, it came with no money and no staff. Even I was not really extra staff because I was taking a career job. But that's been one of the challenges. So we worked really hard, especially in the beginning, to do sort of training of the attorneys to figure out kind of what are these statutes that we have responsibility for, what are the judicial enforcement provisions, because some of them have never been used before. And so there was a lot of kind of training on that and kind of thinking through, talking with the agency to figure out, do they have enforcement issues that they need to work on, and how can we best fit the judicial remedies we have to help them with their mission. So it was a lot of meeting with the USDA and their subcomponents, APHIS, the Food Safety Inspection Service, the IG's office at the USDA, which handles a lot of their criminal enforcement. And there's also a legal policy component. Like I said, one of the benefits of having Main Justice involved is that at DOJ, we often give technical advice to Congress. So we see bills that come through and we're able to comment when they touch on areas that we handle in litigation. Same thing with regulations. So we have that kind of perspective. Not only can we do those things, but after a few years of seeing how the cases are actually working and seeing sort of the pitfalls and different strategies and kind of understanding better how the current process works, we're able to kind of harness all of those and actually give better advice to Congress, to the agencies. And then also, when it's warranted, we're able to kind of put forth affirmative proposals ourselves on the policy front. And of course, then there's the cases. Again, the U.S. Attorney's offices continue to have joint authority to work on these cases, and that's primarily where the resources are in the field. But we now can assist them. We can take on cases. If they don't have the resources, we can work together with them, handle them separately. And we can also, again, provide go-by samples and take on cases where novel issues are coming up that we kind of want to have kind of a more holistic approach. So just a quick note on the sort of policy and outreach. So again, like I said, we've done a lot of training internally, but we've also been doing things to train our attorneys about what the real processes are under these statutes. And one of the things that we did was we toured a slaughterhouse. I took 5 of our prosecutors to 2 slaughterhouses with the USDA and their inspectors. So this is a picture of before we actually visited. It was not a pleasant experience. I don't think anybody would say that it is. So I don't know why we actually are smiling in this picture. I think it's one of those instincts when someone puts a camera in your face and you smile. But I thought it was important to do this because when you read the Humane Slaughter Act, which is why we went there, it's hard to really understand when a violation is actually going to occur and how one would prosecute that. And going and actually seeing how slaughter is done, seeing it from the perspective of the USDA inspectors and the inspectors at the plant, and understanding from their perspective kind of what they think the law is and what they think they're supposed to do, it really, really makes a big difference for the prosecutors. And it helps them understand some of this is subjective. When you're talking about something like a stun, when you actually go to a plant, it's not that straightforward. The other thing we were able to do from a policy standpoint was we testified to the Sentencing Commission to increase the base offense level for animal fighting crimes. And so again, this was something that kind of fit within our bailiwick because prosecutors had seen how other crimes are prosecuted. They have, over the years, you're able to kind of get a sense of the kind of sentences you can get for similar crimes. So we were able to kind of testify and talk about how most of the cases that we brought under the animal fighting statute, judges were giving sentences that were way outside the guideline range. And so those were the kinds of expertise we were able to bring. And we were able to, along with some of the NGOs, we were able to get the Sentencing Commission to increase the base offense level for this crime. Something else that we were able to do from Main Justice that we weren't able to do before is deal with kind of problems that you kind of see recurring. And an example of this is with the animal fighting. Again, animal fighting and prosecuting that is a challenging thing for the AUSAs in the field and for anybody because you actually have live animals that you have to deal with. And if you are about to, you're about to do execute a search warrant, and there are going to be, you don't even know, maybe 50 dogs, 100 dogs, based on your intel. There's a question of what do you do with those animals, and how does the U.S. Attorney's Office, as a prosecutor, how do you deal with that? What was happening before was that some offices weren't taking cases sometimes because the logistics of that can be kind of too challenging, and the resources that you need can sometimes kind of prevent you from getting involved in that. The other thing that some of the offices were doing was leaning really heavily on state and local law enforcement and NGOs to take the animals. But the logistics of that, whether you need a contract, whether the government can even kind of accept that kind of help, is something that's really complicated. So what we were able to do is work at Maine Justice with the Marshal Service, with the Asset Forfeiture Fund, and come up with a plan for kind of how to help the U.S. Attorney's offices when they get these cases. So now we can quickly get a contract in place. We can use funds from the Asset Forfeiture Fund that we have at the department to pay for the cost of care of these animals, because the statute actually requires us to do that. It requires, if we do seize the animals, it requires us to care for them. So it's not like any other kind of property case. And that's a picture of our deputy chief, Joe Pooks, who's one of our, in our crime section, and doing a Facebook Live event with the FBI, the USDA Inspector General, and ASPCA, which is an organization that helps a lot in terms of the care of these animals. So I want to run through the statutes very quickly, but I think what I'll do is just kind of focus a little bit on some of the cases that we've had. Again, animal fighting is one of the areas where we've really been able to expand. Just in the last couple of years, the U.S. Attorney's offices have been, again, bringing cases. They typically charge about 50 defendants a year. We've been able to add to that in the last couple of years. We've had cases against 15 defendants. We've been able to, just ENRD has been able to work to seize 200 dogs. We've assisted the U.S. Attorney's offices in, I think, around 750 since that time. So these cases are kind of trickling down through the system, and one has now come up on appeal to me. And so this is a case that it's been briefed, but we're going to be arguing in April, United States versus Gaines. And I want to talk about this just to kind of give you an idea of some of the novel issues that come up that we're able to work on. So United States versus Gaines it's a dogfighting case, and the defendant was being investigated by New Jersey for drugs. And on the wiretap that the state had issued, they kind of tapped this guy's phone for about 5 weeks, and they detected 150 hours of communication about animal fighting. So they opened up a new investigation and learned that actually this guy was doing both, separately, but he was doing both. And he was heavily involved in terms of buying, selling animals, training them, setting up fights for other people, all kind of interstate conduct. He pled guilty, so we don't have that issue to worry about. He pled guilty to 3 counts. One was buying a dog Vita from a well-known New Mexico dog breeder, and then picking up the dog at the airport. So great, you've got the interstate commerce nexus. The count 2 was delivering a separate dog. He drove the dog from New Jersey to Indiana to another dog fighter. And then count 3 was when the federal agents actually, after he was arrested, the federal agents searched his home, and he still possessed the dog that he purchased from New Mexico and several other dogs that he kept in stacked shipping crates in his basement with kind of the boarded up so that the dogs couldn't see each other. About 6 dogs in the basement, and next to the dogs were a lot of other equipment, dogfighting training equipment, things like intravenous fluid bags, skin staplers, all sorts of things that people wouldn't normally have. So he pled guilty, and the question here, it isn't about the conviction, but it's about the sentence. The court sentenced him to 42 months. Now, the statutory maximum is 5 years. Something else that I've learned now is that nobody ever gets a statutory maximum. It's pretty rare. In general, it's pretty rare. But under the sentencing guidelines, there's a very, very complicated table that you follow. And even though the guidelines are advisory, the judges still have to use them, and they still have to calculate the guidelines first to figure out what the guidelines should be, what the sentence range should be, and then they can apply their discretion and look at various other factors. So this judge sentenced him to 41 months, and when looking at the sentencing guidelines, which they must do, came up with a figure that included an adjustment. Now, under the guidelines, you have a kind of a base level for whatever the crime might be, and then you can go up or down. You can add points or subtract points depending on things like whether you've accepted responsibility by pleading guilty, whether or not you were a main player in the crime, whether or not whether or not you were involved with multiple counts. There's a rule specifically for what you do when the indictment charges you with multiple counts. And the rule says, as relevant here, that if you have multiple counts that involve the same victim or in the same or connected transactions, then you group them together. And the principle for this rule is basically they don't want to double count. They don't want to get a person for shooting at a police officer multiple times in the same transaction. Here, the defendant argued that the dogs, in specifically count 2, should merge with counts 1 and 3. So the crime involving Bubbles should merge with the crimes involving Vita. The government conceded that the crimes involving Vita 1 and 3 should both merge because they involve the same dog, the same victim, and they involved buying and possession later, the same actor, the same transaction. But count 2, we argued, is separate because there was a separate victim. So the question is whether or not a dog can be a victim under the sentencing guidelines. Good. So it's an interesting case. It's a matter of first impression for the Court of Appeals. What the defendant has argued, and this is all public, the defendant has argued that victim, and the language, the second paragraph is language that is in the sentencing guidelines. It says that the term victim is not intended to include indirect or secondary victims, and generally there will be one person who is directly and most seriously affected and is therefore identifiable as the victim. So defendant's argument is that victim equals person. Animals cannot be victims. And then he also points to a variety of other things, other statutes, the Victims' Crime Rights Act, which talks about the kinds of rights that victims get in court, the right to be able to see the defendant and various other things that don't kind of naturally fit with the idea of an animal being a victim. We have argued that the sentencing guidelines, they're actually mostly written thinking about kind of the most commonly prosecuted crimes. They are not written for the 5 federal statutes, right, that we have here where animals are the intended entity that's being protected by Congress. And so we've argued that that paragraph is illustrative. It is not definitive. And if you look at the definition of victim in the dictionary, it covers creatures, living creatures, and it actually came from the notion of animal sacrifice. And so we'll see what happens with this case. I think it's really interesting. I'm going to keep my comments to this limited because we are going to be arguing this in April. But there are a couple of state court cases that have found that animals can be victims for kind of the equivalent, the state court's multiple count rules, and we have cited to those. Of course, here we're dealing with a different body of law. We're dealing with the sentencing guidelines. So it's not necessarily a perfect match, but one of the things that we have said in our briefing is that the states are the ones that do most of the kind of prosecutions involving animal cruelty, and so looking at kind of what they do makes sense in this context. The other thing is if you get past kind of the plain meaning of victim in the guidelines, then our brief argues that you should look to what did Congress intend here. And if you look then to the legislative history of the Animal Welfare Act, the title kind of says it all, right? It's talking about the welfare of animals. And the legislative history is replete with instances of legislators even using the word victim. Legislative history doesn't always work so well with some of the judges, but I think looking at the structure and the purpose of the statute and then those other kind of indications in the history are really strongly suggestive of what Congress wanted to do here. So that's one of the cases that we've got on our table. So I'll run quickly through some of these. The Animal Crush video statute, it is a statute that criminalizes the obscene presentation of animal cruelty. We've had a couple of cases. I think there's only been 2 since the statute has been re-amended after it was initially struck down. The Animal Welfare Act, this covers a huge swath of conduct dealing with the welfare of animals in commercial settings, in circuses, and zoos, laboratories. Again, this is a very complex statute because of all of the the tools that the agencies have to be able to give permits and to give warning letters and various escalations of penalties. So DOJ's involvement here, hasn't been, we haven't had a lot of cases because a lot of the work happens at the agency level. The Horse Protection Act, this is a law that targets a really specific type of conduct, the soaring of horses, so that they can kind of have an artificial gait that's prized for fighting. It's prized for the walking horse industry. We've had a number of cases actually prosecuting people for transporting and exhibiting sword horses. Something about this that's interesting is, again, soaring of horses, which is kind of putting a chemical or abrasive ingredient on their limbs. That's not actually illegal under federal law probably because of the Commerce Clause, right? It's what's illegal is exhibiting the animals or transporting the animals or doing other things that kind of gets them and gets your nexus to interstate commerce, which again complicates the kinds of prosecutions you can bring because the underlying animal cruelty is really more of a state issue and it's harder to get at that through federal law. But we have had a number of cases there. And the Humane Slaughter Act and the 28-hour law. So I think of these together, although the 28-hour law was really about kind of transporting animals by railway and making sure that they had enough sort of pit stops and all of that. It's really fell into disuse, I think, because of the limited way of being able to detect if people are transporting animals for longer than 28 hours without stopping. The Humane Slaughter Act, again, mandates basically a humane death. It's, again, targets a very, very specific type of conduct. It's whether or not you stun an animal before you kill it so that its death is, so that it is rendered insensible to pain before it is actually processed. And so it's a very specific type of conduct. Again, we've been working with the Food Safety Inspection Service on that. It's interesting because there have been a lot of developments at the state law level. And here you probably know about Massachusetts passing a law, I guess it was last year, dealing with farm animal cruelty. California has been doing that. We actually at the department, so ENRD was able to consult on a case that came to the department. It didn't involve the United States as a party, but it involved states suing other states. So some of the states, Indiana and others, sued Massachusetts and sued California for their farm animal laws because of one component. It wasn't that the state wasn't allowed to prohibit cruelty to farm animals, but what they were arguing is that a state shouldn't be able to prohibit the sale of meat that was produced in an inhumane way. And the states that were challenging these laws were arguing that that violated the Dormant Commerce Clause because it prohibited Indiana, for example, for selling its meat to Massachusetts or California. So the United States, again, this is state law. It's not one of the ones that we enforce, but the Supreme Court asked for the views of the Solicitor General, and we always respond when we're asked. And so we got to our division got to sit in and participate on those discussions, which was really fascinating. And something that I sort of took away from that whole process is kind of how the populace really affects how the law is examined. And I will say, so the United States filed a brief saying that the court should not hear these cases. These cases, they involve kind of three really different and interesting issues. One was whether the Supreme Court should hear an original action between state versus state directly in the Supreme Court. And that's a pretty high burden. Obviously, we don't want the Supreme Court taking kind of every case that could come up between states. And so we argued that that's just, that this didn't meet that threshold. It also involved whether a state had parens patriae standing, whether the state should be able to stand in the shoes of its people to challenge this law. And then finally, the Dormant Commerce Clause question as to whether or not this was really going to burden that state. And when the two latter, the standing and the Dormant Commerce Clause, something that we noted in the brief, the Solicitor General's office's brief, was that it wasn't clear, at least in the pleadings, it wasn't clear whether these kinds of laws were really going to be burdening Indiana's meat producers. And the reason why was because there was something else going on, we said in the brief. We said, actually, consumers are making different choices too. And how do we know if prices go up or if you project prices are going to go up when this law goes into effect, how do we know it's because of one state prohibiting your products from coming in, or if it's actually because consumers are demanding, this cruelty-free meat? I mean, we don't necessarily know. And when I thought about that, it was interesting because, and I'll get to this later, DOJ has a pretty narrow role, but when things change because of NGOs, because of the population shifting demands, that affects how we interpret the law. That affects kind of how the law gets applied to a particular set of facts. And here, if you have a whole bunch of state initiatives that say, we don't want this kind of product, or if you have people just sort of through their consumerism demanding a different kind of change, that actually goes into the legal test that you apply, which I just thought was really, really interesting. I mean, you see that, I saw that really in my non-animal law work, looking at, kind of cases involving substantive due process and Ninth Amendment. I had a case in the civil division involving medical marijuana, and in that case, people were arguing that there's a fundamental right. And even in that debate, the question comes up about what are the states doing, and has there been enough of a change? Have there been enough of 22 states, 25 states to kind of look at that to see how many, how is the population's change really affecting state legislatures and the law? And that kind of affects the question and the analysis at the federal level. So it's kind of an interesting way that changes in kind of population can affect the legal question and the way we analyze things. So these are just some kind of press releases from our work. Again, it's still a work in progress. I was telling Kristen earlier, again, we don't have any money for our program. We don't have sort of specific people that are dedicated to just animal welfare work. We have, me who's doing appellate litigation, but I have this hat on. We have a couple of attorneys in our crime section who are pretty much full-time working on this, but they're not necessarily only working on animal fighting and animal welfare cases. And we have folks who do kind of on the civil side are available to do civil penalty cases, civil forfeiture cases, and the like. But there's no kind of number of people that are devoted to just this topic. And I should say that that's not unusual, because in our division, the entire ENRD is about 500 people. And so one of the things that we like is we're specialized to some degree, but the attorneys, we're able to kind of take on all sorts of cases. So I think I'm going to kind of go to the last point, which is lessons learned. It's only been a few years where we've had animal welfare having a home at Maine Justice. I have a lot that I'm saying right here, but I think I could probably sum it up by saying, kind of Chris asked me to talk about kind of where DOJ and our program fits in terms of the broader landscape of animal law and animal welfare. And I think I would put it this way, is that DOJ's mission is not animal advocacy, right? That's just the way it is. Our mission is law enforcement. But when the laws are written in a way that, promote animal welfare, then that does become our mission. It's kind of a common sense notion, but it really affects kind of everything that we do in the department and the way that we are, the way we have to operate, I think, in order to satisfy our jobs and to do our mission, right? So I think that affects kind of how we look at legislation. We can provide technical guidance based on our experience, and we can inform policymakers about how a case would be brought, but our mission is law enforcement. That's not to say that, again, animal welfare is not a big component of that, but we are limited by the statutes and by kind of our role in that. I think you see that divide when it comes to whether you're talking about a government agency versus an NGO. We all have kind of different parameters. I think it's further exacerbated in a way when you're talking about the federal government, because we are confined by the federal statutes, and those themselves are confined, right? We're obviously a government of enumerated powers, but that really plays into kind of what you can do in terms of animal welfare, because the Commerce Clause limitations. I think a lot of work in this space is done at the state level because they don't have those kinds of limitations. Again, you see kind of the preemption angle with the state versus state laws. And you also see the role of the institutions. Even in the federal government, with these restraints, we then have to kind of look at what is DOJ's role versus what is the role of the agencies, right? There are agencies whose mission is animal welfare, but is also to kind of give licenses to people who are exhibiting animals. So they have those kinds of sometimes conflicting roles to deal with. The last point I will make is kind of in terms of career paths. I think my lesson here was just to expect the unexpected. I did not think that I would be doing any animal welfare work in my career, especially after that really mean tort professor said what he said. But I think what I gained is that I think I would just advocate for law students now to get the best general kind of legal training that you can. I think the things that you learn in different places will help you in ways that you won't really realize until they do, right? Becoming the best litigator, the best thinker, the best legal writer, all of these tools really, really help you. I ended up doing a detail in the White House counsel's office. Again, nothing with animal welfare, but I got to see how at that level, the administration kind of puts out policy agendas and how they try to get their mission and their different ideas down to the agencies. And seeing all of those things, I think really kind of played into what I was able to do at the department. So with that, if there's any questions.
Great, yeah, Joey, we've got about 10 minutes for questions, and because we're recording, please put your hand up and so I can give you the microphone to ask your question. Oh.
So what you said at the end was, I think, quite important, and you mentioned it when we were talking beforehand, which is your dependence on the agencies. And we would love it if the DOJ could walk into a slaughterhouse and impose the kind of penalties that you have discretion over, but we know that there's a long process that has to happen first before it even gets to you. Could you say a little bit about that and the extent to which you have to wait for your agency, at least in those four acts that you sectioned off as the second part?
Sure. So I think it depends on if you're talking civil enforcement or criminal. With criminal enforcement, the U.S. attorney's offices and prosecutors, you have a little bit of an independent role. Again, even there, prosecutors don't take every case. They don't prosecute every crime. But in both contexts, we rely heavily on the agencies for bringing us the evidence. And, having the law enforcement agents. Something that I didn't appreciate was that the prosecutor doesn't just kind of build a case. It's not like just writing a brief. You actually need to have agents that are specific agents under Title 18 who can carry a weapon and go and execute search warrants. So there's only certain places in the government where those agents exist. We have them at the FBI, USDA's IG's office has them. We need those agents to actually go out and get information. And it can't always just be civil actors. It can't necessarily be even APHIS. It has to be law enforcement agents gathering the information that we can then put into a search warrant, to do that next step or to give to the grand jury. So I think we're dependent on having sufficient evidence. How we get that evidence and what's sufficient, that's all kind of very fact-driven. But we need that before any prosecutor would think about taking any case, whether it's in this space or not.
Another question?
Hi, thank you very much for that presentation. My question is, has and how has your work specifically within the animal law space at DOJ changed since January 2017?
So it's a good question, and I know a lot of people are interested in that. I don't think it's actually changed. We had an animal welfare program that was a fledgling program, right? Around 2015. We still have that program and we still have that support. This is one of the areas that I think isn't really a partisan area. And I will say that the Assistant Attorney General that came into the Environment Division has been supportive of these efforts. So I think the hurdles that we faced in terms of resources and that sort of thing have been constant throughout. Mm-hmm.
Any other questions? I've got a quick question. So you mentioned, I remember you telling the story about the sentencing guidelines, and everyone else at ENRD was extremely jealous at how rapidly you got those through. You want to explain a little bit about that?
Yeah, so, and it wasn't something that DOJ did on its own. It was, I think, an initiative that was pushed by ASPCA and HSUS. But the sentencing guidelines, I think the comments that were provided by the public, they received the most comments on any topic ever when, in terms of increasing the guidelines. And then it happened within a few months. People at ENRD were jealous, I think, because they've been trying to increase the penalties for various other crimes, environmental crimes like vessel pollution and the like. And they're like, we've sent in proposals and they've been stuck for a long time. And, animal welfare kind of, because of the public interest, I think it moved forward in a much faster pace.
And on the case that you were talking about where whether each count in treating the animal as a victim, did you seek out amicus briefs from outside organizations who might have already worked on some of those issues at the state level?
We didn't, and I think in part because it's a criminal case, and I think that our briefs, at this level kind of were sufficient and did what we needed to do. I think if it went to the Supreme Court or if it were a non-criminal case, that might be more appropriate, but that's where we are. Yeah.
Any other questions? Here we go.
Thank you. I'm not a law student, so that this is basic. Sorry. But I'm wondering, especially when you're talking about the case of meat selling state to state, what are the ways in which the meat industry and these corporations with a lot of money influence the way law is enforced?
That's a good question. I don't know that I have any sort of expertise on that. I think in terms of at the federal level, in terms of the actual enforcement of the Humane Slaughter Act, again, that's a sort of a separate question from states being able to stop other states from selling. At the federal level, we have an independent U.S. Attorney's Office and independent prosecutors who make those determinations. Can you talk a little bit more about what you're talking about in terms of the state versus state question?
I guess I was just referring to, I'm wondering where were the motivations for Indiana to bring this case against Massachusetts?
That is a good question. I don't fully know. I will say in their briefs, one thing that they pointed to was, Purdue University gets state funding and they have a hog farm and they have they sell meat themselves. So I think one of the things that the states were arguing, not just Indiana, but others, was that as institutions, sometimes they sell meat, but they also, universities and schools, they buy a lot of meat. And so they argued from a standing perspective that if the meat prices went up, if the egg prices went up, that would actually affect kind of the purse in terms of the state's fiscal resources. That was, at least that's what they said was the primary impetus.
And I can speak a little bit to the Massachusetts law. Unlike at the federal level where it has to kind of go through the agency first before it gets to DOJ, with the Massachusetts ballot injury goes to the Attorney General has all the authority to directly enforce. It doesn't need to go through another agency first. And the states who have passed these laws are pretty excited about enforcing them.
My question is about the Animal Welfare Act. Does it have enough teeth in it really to prosecute much of anything? And what have you seen in your work so far that you might use to advocate to strengthen the Animal Welfare Act? I mean, it's the same act that's been there for many, many, many years.
Yeah. So from a judicial enforcement standpoint, the provisions are pretty narrow. The agency can do a lot of things, like even revoke licenses, which in some ways is kind of a showstopper for an entity. From the judicial enforcement standpoint, there's a criminal provision. It's a misdemeanor. So that's one thing. I mean, I think if you're looking at, I think the DOJ looks at kind of all crimes and thinks about them, especially if there haven't been prosecutions. But having something be a misdemeanor is always kind of, doesn't necessarily get the priority as other crimes that are happening. So when you're competing for resources from that standpoint, that low-level penalty can sometimes be a problem. There's also a civil penalty provision in the AWA, but that, again, it requires the USDA to kind of get a final judgment before an administrative law judge and see that through the Court of Appeals. And then if they get a judgment against an entity for violating the AWA and they don't pay, then we can go in and kind of have higher penalties and sanctions. But that, again, is kind of relying on there to be a full agency decision. And I will say the AWA, it makes violations a crime if it's a violation of the statute. And something that I didn't really realize until kind of really getting involved in the statute is that the humane handling parts of the statute where the regulations all kind of lay out exactly what you can do with each type of animal. Those are all regulatory. They are not listed out in the statute, and they're not technically, if you violate those, it's not a violation of the statute, so it's not necessarily a crime. Violations of the statute would be really limited to things like exhibiting without a license, transporting an animal without a license. So from that standpoint, our judicial enforcement is limited currently by the statute to those types of things.
All right, I think that's a good place to wrap it. There's some handouts here related to the division. And again, please join me in thanking Varu for her time.
Thank you.
Oh yeah, sorry. So, and just to let folks know, we've got 3 more events for our Animal Law Week this week. Tomorrow, we've got an international undercover investigator talking about his experiences. On Thursday, we have Kitty Block, the president and CEO of the Humane Society of the United States. And on Friday, we're doing a panel discussion about accelerating alternatives to animal experimentation. Thanks so much.